Okay, the last in this series for topic 10 covers terms that are implied by statute. Now, the principal issue here is to understand that in addition to the common law, there are statutes that apply or imply terms. And there is a kind of trick to understanding how they work, which is something that you're going to need as you work into the next topic and start thinking about exclusion clause. Now, the provision that we're going to spend, or the legislation we're going to spend our time using as an example for here, and by far it's not the only legislation that implies terms, is the Australian Consumer Law. And we're going to look specifically at these consumer guarantees. Now, this slide, I'm actually not going to talk to it one by one because it's less and less relevant as we go through the years. The reason I bring it up is the Australian Consumer Law is actually Schedule 2 to the Competition and Consumer Law. The Competition and Consumer Law itself replaced the previous law, the TPA, or the Trade Practices Act. Now, the most common or most often litigated section of any legislation ever in Australia was Section 52 of the Trade Practices Act. That's now reproduced as Section 18 of the Australian Consumer Law. So what's that section? That's the section that says, and I am not quoting it directly, "Thou shalt not in trade or commerce do stuff that is misleading or deceptive." It's a strict liability provision. It basically, you offend the provision if someone is or could be misled or deceived. And if you ever do competition and consumer law, which I strongly recommend you do if you're enjoying a subject like this one, you'll spend a lot of time understanding what trade and commerce is, thinking about the misleading or deceptive, whether they're two separate things or one separate thing. Or one individual thing, I should say. But it's important to understand that also you don't, even though if you offend the section, what that does is initiate a cause of action. It doesn't of itself give rise to a liability. So other provisions that were in the Trade Practices Act that are now in the Australian Consumer Law provided for what were previously statutory warranties and are now called customer guarantees. This slide, have a look at your slide pack if you can't read it on the screen here, tries to just highlight the similarities and differences between that part of the regime. Now, I don't propose in this video to go through these summaries in any great detail. Really, what is the point here? The point is, if the legislation provides a term that is to be implied in all categories or all contracts of a particular class, then it's really important to read the legislation carefully. In order to understand how the consumer guarantees work, it's important for you to understand when do they apply and how. What is a consumer guarantee? What is a consumer contract? What is a small business contract? When do they apply? And then to understand exactly what they are. Now, what's really important about these particular provisions is you cannot exclude them. So you cannot include an exclusion clause in your document that says, notwithstanding anything else that might be in legislation, we don't give you any warranties as to fitness for purpose. Now, that's quite different from terms that are implied as a matter of law. So we've previously identified that in the category of contract sale of goods, there is an implied term that goods will be of merchantable quality. But if they're not of merchantable quality and the parties have agreed it, the term in the contract can specifically provide that I'm going to sell you a bale of rotten apples. I don't know if apples come in bales or not, but I think you see the point. So basically these slides, they're provided here as summaries. They're never going to beat actually reading the chapter in your textbook, or even better, going and having a look at the law. I'm trying to highlight what the key points are for you. So one of the first things that you need to think about in relation to these issues is who's a consumer? who gets the protections of a consumer. To do that, you need to look at the definitions, and in this case, in particular, Section 3 of the Australian Consumer Law. Now, what you'll find interesting is a consumer isn't what we, as far as the law is concerned, what we immediately think of as a consumer. I think of the consumer as somebody who goes to a retail shop and buys some retail goods. That's what consumer means in the ordinary sense of the word. But as far as the law is concerned, the statute defines consumer by reference to the size of the transaction and the type of transaction it is. So a consumer transaction is any contract for the sale of goods or services where the cost of those goods or services is $40,000 or less, or if those goods or services are of a type that are normally acquired for personal, domestic or household use or consumption, then their value could be more than $40,000, or a vehicle or trailer principally used to transport goods on public roads. Go figure. So a $60,000 sofa is a consumer transaction. A B-dub truck, those double trailered trucks, which is used to transport goods, buying one of those, I think they cost $150,000 or probably more, that's a consumer transaction. A purchase of a stud ram for $40,000 or $39,999 is a consumer transaction, but a purchase of the same stud ram for $10 more would not be. So the purpose of this slide is to give you some examples of the difference between consumer transactions and non-consumer transactions. My stud ram example is on it. Have a look, make sure that you understand. The thing I think actually I probably didn't mention when I was on the last slide, didn't say out loud, is that one of the things that will exclude something from being a consumer transaction, let's just have a look at it, so the words highlighted in green here, is a person won't be a consumer in any of these cases if they acquire the goods for resupply or to use or transform them in a manufacturing or production process or in the course of repairing or treating the goods. So for this reason, kids who buy lemons to turn them into lemonade at a school fete, so in other words, they're processing those lemons to turn them into something else, won't be consumers, though a small business that purchases toilet paper for employees and visitors will be. So what kind of goods or services are covered? So here, this is possibly an overly complex slide, but what I'm trying to do is demonstrate to you that it is important that what you do when you're analysing whether or not a term that is implied by statute applies, you need to dig down into the definitions. So I've used this sort of three-part analysis. Is it a consumer transaction? Has it occurred in trade or commerce? Which is a pretty easy test as it turns out, and is it purchased after the relevant date? So for consumer transactions, we're talking about after the 1st of January 2011, which is nigh on irrelevant now. It's a significant number of years ago, but what might be more relevant is whether the transaction, if it's a small business transaction instead, has happened since November 2016. So take a look at that, but really the point of that slide is not so much to tell you what to do in those circumstances, but to give you an idea about the kind of analysis that you need to do in order to work out if a statute implying terms actually applies to your situation. I mentioned small business contracts before, and since November 2016, these have also been covered, so small business contracts have been covered by the Australian Consumer Law. So the provision, section 23 sub 4, provides that a contract is a small business contract if A, the contract is for the supply of goods or services, or for the sale or grant of an interest in land, and B, at the time that the contract is entered into, at least one party to the contract is a business that employs fewer than 20 people, small business. And C, either of the following applies. So we need either an upfront price of less than $300,000, or if the contract has more than 12 months duration, and an upfront price of less than $1 million. So So we've got two categories for working out whether it applies. It's also worth noting that subsection 23(5) provides that in counting the number of people employed by a business for the purpose of working out whether it meets the 20-person threshold, we don't count any casual employees unless they are employed by the business on a regular and systematic basis. Okay, let's give you an overview of what I'm talking about here. What are the consumer guarantees that the law requires be included in all consumer contracts and now small business contracts? They're summarised here on this slide. The seller has the right to sell the goods. In other words, if you say you're going to sell something, you have the right to do that without any other interest being affected. The consumer or the purchaser has the right to undisturbed possession of those goods once they acquire them. There aren't any undisclosed securities attached to the goods, so no other person has the right to come and repossess them. Now, these are terms that mirror terms that are implied by law in relation to the sale and purchase of goods. The goods are of acceptable quality, another term that mirrors the law here. So anyone who supplies goods in trade or commerce to a consumer guarantees that the goods are of an acceptable quality, which is something different from merchantable quality, but acceptable quality nonetheless. This means it needs to be fit for the purpose that the goods of that kind are commonly supplied for, and acceptable in appearance and finish, free from defects, safe and durable. Fifthly, the goods need to be reasonably fit for the consumer's particular purposes if that purpose is disclosed by the consumer to a supplier. So if I go and buy, say, a high-pressure water cleaner, the kind that's usually used for cleaning decks, it needs to be suitable for cleaning a deck. But if I disclose that I'm going to use it to clean my elephant, and it turns out it's wholly unsuitable for use in elephant cleaning, if I've actually told the supplier that I'm using it for that purpose, there is an implied warranty that it will be fit for that purpose. That puts the onus on the supplier to tell me, no, Kath, no elephant cleaning with this particular device. Goods need to match the description that's given to them. Suppliers and manufacturers need to guarantee, there's an implied guarantee that the goods will correspond with any description. Goods also can't differ from any sample or demonstration model that's shown to the customer. Repair facilities and spare parts must be reasonably available. And finally, in relation to goods, additional express warranties, so motor repairs free of charge for 10 years, must be complied with. In relation to services, there are three key guarantees. Basically, let's summarise them as follows. There's a guarantee that you will provide services with due care and skill. Any business providing services to a customer needs to guarantee that they'll be provided with due care, knowledge and skill. This means that the supplier needs to have the knowledge and skill required to provide those services in an acceptable way and take all reasonable care to do so properly without causing loss or damage. So an example of this might be Main and Nicholas and Crawford, a 1992 South Australian Supreme Court case, where a home security company which was installing a security alarm system was required to carry out the work in such a manner that the alarm would be activated if a burglary happened. Or Reed and Neary nominees, 1979, a Victorian Supreme Court case, a garage that agreed to repair a car needs to properly diagnose what's wrong with the car and skillfully carry out the repairs. The second guarantee here is providing services for a particular purpose or a desired result. So if a consumer makes known to a supplier that they want the services for a particular purpose or to achieve a particular result, then there's a guarantee that the services and any product resulting from those services will be of such a nature and quality, state or condition that they might reasonably be expected to achieve the stated result. This is in addition to the guarantee that the services are provided with due care and skill. It doesn't apply if the supplier's skill and judgment wasn't relied on by the consumer, or it was unreasonable for the consumer to rely on them, or to professional services that are provided by a qualified engineer or architect. Just that's as a consequence of Section 61, subsection 4 of the Australian Consumer Law. An example of this is from the case Garbian and Propix, a 2007 decision, New South Wales decision, where it was found that rides in an amusement park need to be reasonably safe when they're operated by the patrons, and the kind of patrons that the proprietor can anticipate will use them. Yes, New South Wales decision. I suspect we'll see some more about that out of Queensland eventually. Lastly, services needed to be provided within a reasonable time. If a time frame for a business to provide services isn't part of the contract, or the contract doesn't provide a manner for determining what the time frame should be, then there's a guarantee that they'll be supplied within a reasonable time. What's reasonable? It's going to depend on the nature of the service and the circumstances in which they're provided. The next point here is I've just created this table to demonstrate that the guarantees cover a range of things. I've got the section numbers there for you, but they also are given by both the supplier and the manufacturer depending on the requirement. So any person who sells goods to a consumer guarantees that they have the right to sell them. This means that they need to be able to pass ownership to the consumer, and there must be no restriction on this. It applies to both the supplier and the manufacturer. Again, in relation to goods, anyone who supplies goods to a consumer guarantees that the consumer has the right to undisturbed possession of those goods. So, for example, the supplier guarantees that no one else has the right to repossess the goods or to stop the consumer from using them. Once again, this one is given by the supplier. There are no undisclosed securities attached to the goods given by both supplier and the manufacturer. So anyone who sells a product to a consumer guarantees that it is, and it'll remain free from any security or charge unless those were disclosed to the consumer in writing before they agreed to purchase the product, or they were created with the consumer's express consent. So a good example of this is that the seller of a car needs to ensure that any security over the car given by the previous owner, such as a hire purchase or a car loan, has been discharged before it's sold to a new buyer. The next one, spoken about a couple of times, again reflects the position of common law. Goods need to be of an acceptable quality. So anyone who supplies goods in trade or commerce to a consumer agrees that the goods are of acceptable quality. The section 54 sub 2 provides that the goods are of acceptable quality when a reasonable consumer would regard them as being fit for all of the purposes that goods of that kind are commonly supplied for, acceptable in appearance and finish, free from defects, safe and durable. When deciding whether the goods have these qualities, a reasonable consumer needs to have regard to the nature and price, if they're relevant, of the goods, the statements about the goods on their packaging or their labelling, any representations made about the goods by the supplier or the manufacturer, and any other relevant circumstances relating to the supply transaction. An example, Ryan and Great Lakes Council. In that decision, it was found that contaminated food is not of an acceptable quality. Go figure. Or in Russell and Cavalier Marketing, 1991 Queensland decision, custom-made carpets that weren't uniform throughout a house were not fit for the particular purpose for which the carpet had been acquired, when uniformity had been specifically required and the consumer relied on the skill and the judgment of the supplier. Next, goods will satisfy any extra promises made about them. Express warranties, section 59. Again, this is given by both the supplier and the manufacturer. This guarantee doesn't apply if the consumer bought the goods at auction though. Some examples, second-hand farming equipment wasn't fit for the purpose for which it had been acquired when, because of a number of defects, it soon became unworkable, which is contrary to what a reasonable purchaser would have expected in the circumstances. Zavella and Geiger, G-E-I-G-E-R. I don't think the point of this section is not, you don't need to understand the ins and outs at this stage of each of these guarantees. What you need to understand is that they exist and that they apply, whether they're for goods and services or goods or services, whether they apply to the supplier or to the manufacturer, and that they cannot be contracted out of. and that as guarantees, basically they provide directly for a cause of action and a remedy to be relating to those guarantees that can be enforced against both the supplier and against the manufacturer. What you can see on this chart here is a flow chart. Comes out, it's actually taken from the ACCC website a few years ago now, and I don't have, naughty me, a proper citation for it. It's not there anymore. But I think understanding that that there is a regime that provides for remedies against the suppliers and the manufacturers that can't be opted out of is what is important here. Now, there are in the slide pack some additional provisions here that deal with basically what the test for acceptable quality is. Again, so I spoke about that just a minute ago, probably in the wrong spot. So let's recap here. Anyone who supplies goods in trade or commerce to a consumer guarantees that the goods are of acceptable quality. Section 54.2 provides that the goods are of acceptable quality when a reasonable consumer would regard them as being fit for all the purposes which goods of that kind are commonly supplied, acceptable in materials and finish, free from defects, safe and durable. And it's important to note that the ACCC has responsibility for product liability and product safety across its portfolio of responsibilities. And when deciding whether goods have the qualities, a reasonable consumer needs to have regard to the nature and price, if they're relevant, of the goods, any statements about the goods on their packaging or the labels, any representations made about the good by the supplier or the manufacturer, and any other relevant circumstances relating to the supply transaction. So basically this slide here is really illustrating those points, the way that you just think about, flicked a bit quickly, about what is the good, are the goods of acceptable quality, and what are the tests that we use to identify that. It's worth noting too that second-hand goods that are sold in trade or commerce are also covered by the guarantee of acceptable quality, but age, price, conditions, all those things need to be taken into account. So a consumer who buys a second-hand washing machine for $250 from a shop, and the supplier said it was 2 years old and in good condition, but it breaks down after only a short period of time, a reasonable consumer would expect to get more than 2 months use from a washing machine, given that it's new and that it was relatively expensive. The consumer in that circumstance would be entitled to a remedy from the supplier. Similarly, in relation to leased or hired goods, consumers have a right to expect that goods will be of an acceptable quality. Consumers hire goods when they pay suppliers for the right to use them on a temporary, short-term basis, and a lease is something similar, but it usually involves payments in regular instalments over a longer period of time. Consumer goods that are leased or hired to a consumer must be of an acceptable quality, and so, let's use, have you ever been to the supermarket and bought one of those, or hired one of those steam cleaners for your carpet? If you go and hire that for a day, but the machine doesn't actually generate any steam, or it leaks, or it leaves dirty marks on your carpet, you'll be entitled to a remedy because the steam cleaner isn't of an acceptable quality. It doesn't matter that you didn't buy it, that you were only hiring it on a short-term basis. The guarantee of acceptable quality doesn't apply if suppliers alert consumers to defects. So buying seconds and samples, for example, or stating that you're going to use the thing for an abnormal purpose. So some goods mightn't be of an acceptable quality, but they can, because of a problem that's already known, but they can still be sold as seconds or samples. Defective goods can be sold, and they're usually sold for lower prices, if the consumer is alerted to the defects before the sale. For example, the supplier would need to tell the consumer before selling the goods, or have a kind of written notice of some sort, clearly presenting and in legible and plain language that there were defects in these goods. It won't be enough to just simply describe them as seconds or samples or sale items or as is. A consumer is assumed to be aware of the defects if a written note setting out the defects is displayed with the goods. And when a consumer is alerted to the defects in the goods before sale, they don't have a right to a remedy if those particular defects later cause problems with the goods. Different defects, on the other hand, they may well. So a lot of goods are sold with a warranty against defects. This is often highlighted on a label or packaging or attached to some sort of sales document. So something on a box that says 2-year warranty or 12-month replacement guarantee, that kind of thing. The warranty against defects is also often described in a document outside the product packaging. The one that really gets my goat is when you're upsold an additional warranty or guarantee. All documents evidencing a warranty against defect must be presented in a certain way and must include specific information to ensure that customers understand the warranty and know how to make a claim. A document that evidences a warranty against defects includes any material on which there is writing or printing, or on which there are marks or symbols which contains descriptions of the features or the terms of a warranty against defects. While such a document will usually be a piece of paper or a pamphlet outlining the terms and conditions of the warranty and be provided by a business inside the packaging, in some circumstances the packaging itself may also be considered a document evidencing the warranty. So where a product's packaging is considered to be that kind of document, and there are also warranty documents inside or otherwise attached to the product, the regulations made under the Australian Consumer Law will consider the warranty against defect requirement as being met, provided that the information required by the ACL and the mandatory text are included with the documentation and the information is not inconsistent with the statement on the packaging. The mandatory information must be available with the product itself. It's not sufficient to refer consumers to information on a website or in store. So to finish up, a representation will only be a warranty against defects if it's made at or around the time the goods or services are supplied. A promise about a supplier or manufacturer will do if something goes wrong with a good or a service. Blah, 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 blah. So to finish up, a representation will only be a warranty against defects if it's made at or around the time that the goods or services are supplied. A promise about what a supplier or a manufacturer will do if something goes wrong with a good or service can be a warranty against defects under the Australian Consumer Law, even if it's not provided in a formal document. Any material with writing on it could evidence a warranty against defects, for example, wording on the packaging or the label if those words contain that kind of promise. And the regulations prescribe exactly how the warranties need to be made. For example, they must be available with the product itself, not on a website, must be consistent with packaging. So, basically, I've given you in this slide pack a pretty good overview of some of the statutory guarantees, and in particular we're focused on the warranties against or the guarantee against defects. What's the point here? Do you need to know everything there is to know about the guarantee against defects or the statutory guarantees? No. What you need to understand is that once you've looked at what the common law does in relation to the implication of terms, you also need to think about whether in a particular transaction the legislation will imply a term. When does it do this? Particularly does so in circumstances where the parties to a contract aren't equal. They don't have equal bargaining power. And as we approach the next topic, we'll talk more about the use of unfair contract terms legislation to provide for a level of fairness. Why does this matter? Well, you'll see, going back to the Byrne decision, as we think about the ways that courts fill the gaps, the courts more and more say it's not their job to make law or to provide normative statements. What their job is to do is to interpret the contract using consistent principles and an objective understanding. If we want as a society to require certain things of certain people in certain types of transactions, then it's the role of the legislation to do that. And the first question we need to ask ourselves when we're thinking about particularly excluding certain obligations or liabilities, which is what we'll get to in the next section, is whether there is a requirement of law that a particular standard applies. And if it does, does the statute allow us to exclude that or not? And that's the question I'll leave you pondering until we get back to topic 11. Look forward to seeing you there.